Thank you so much for allowing me to speak today. It's a pleasure to be here. So we're going to go over, like the title says, the do's and don'ts of sexual harassment. We're kind of going to cover all harassment because in California, it's not just sexual harassment you need to be worried about. Oh, that's pretty small, but basically there are two governing bodies that we are subject to here in California regarding enforcing sexual harassment laws and all harassment laws and determining what those laws are. The first one is the federal law and the governing body. The EEOC, the Equal Employment Opportunity Commission, is the governing body regarding harassment and discrimination laws for the federal government. And they enforce the laws that make it illegal to discriminate against a job applicant or an employee because of a person's race, color, religion, sex, including pregnancy-related issues, national origin and age, particularly if you're 40 or over, and a disability or a genetic deformation. This law that the EEOC governs is applicable to all types of work situations, including hiring, firing, promotions, training, wages, benefits, all that kind of good stuff. And the actual law is under Title VII. It was passed in 1964. It's part of the Civil Rights Act. And basically it makes it illegal to discriminate against someone on the basis of, again, their race, color, religion, their national origin, their sex. Basically that's it. And it makes it illegal to retaliate against someone who brings forth a claim based on discrimination for one of those protected classes. The law has been amended recently to include the Pregnancy Discrimination Act, which makes it illegal to discriminate against a woman due to pregnancy, childbirth, or any pregnancy and childbirth related medical conditions she might be facing. So basically that just means you can't pass someone over who would be due for a promotion because they're going to be out for pregnancy and things along those lines. The next one is particularly important to us here in California. It's our state laws. And the California state laws are a little more intense than the federal laws. So the Fair Employment and Housing Commission is the governing body we have to deal with for harassment issues here in California. And they ensure that the people of California are free from unlawful discrimination in employment, housing, and public accommodations. And this particular governing body also includes hate violence. And basically the law that we're under in California is the Fair Employment and Housing Act, which defines sexual harassment as harassment based on sex or of a sexual nature, gender harassment, and harassment based on pregnancy, childbirth, or related medical conditions. And the definition has all different types of facets to it, which we'll go over. But it includes offensive behavior, including harassment of the person of the same gender as the harasser. So you kind of heard me mention protected classes a few minutes ago. And the federal government has protected classes too, which are encompassed here in the California protected classes. California has some additional ones than the federal government has, so we're just going to focus on the California protected classes because that's basically the ones you need to be concerned with. So we already spoke about race, religious creed, color, which race, color, national origin, and ancestry are all kind of the same thing. Physical disabilities, mental disabilities, your marital status, your sex, age, or sexual orientation. The federal government doesn't protect against sexual orientation, but we live in California, so we have to deal with that additional protection. And again, the age requirement is 40 or over. So you can't technically, under the law, harass someone or discriminate against someone who's under 40. Anyone have any questions about these different protected classes?
Over 40 you can
Yeah, so that just means someone can't bring a claim, like an age discrimination claim against someone under 40. Because you can't discriminate based on someone's age if they're under 40.
Isn't it the reverse?
No, you can only bring claims for discrimination against your employer if you're over 40 for an age discrimination.
That's what I meant.
Yeah, so if you're under 40, you can't bring a claim for that. If you're over 40, you can bring a claim.
Misunderstood what it's saying.
Sorry, yeah, so again, you can't discriminate against someone's age if they're under 40.
That applies only to the sexual harassment though, under 40.
No, it's age discrimination. Yeah. So sexual harassment.
It didn't sound right. You know?
The sexual harassment is one facet of harassment laws and discrimination laws. These governing bodies that I previously mentioned, they cover all of these things, which you have to be cognizant of and responsible for. So sexual harassment is, like I said, just one portion, but age discrimination, all these discrimination things are included in this sexual harassment law, even though obviously if you're discriminating against someone's age, you're not sexually harassing them, but it's included in that law. Governments. So there are all different ways you can actually harass someone. So we're just going to go over a few lists here, or a few examples here. So obviously an obvious one is unwanted sexual advances. You know, if you're trying to touch someone or hug someone or continually asking someone out on a date who doesn't want to go out with you, eventually they're going to feel harassed by you, so yeah, knock it off. Another big one follows under quid pro quo, which I'll go over in a second, is offering employment benefits in exchange for sexual favors. So, you know, go out on a date with me or sleep with me and I'll give you that promotion, or I'll give you that extra vacation time, and things like that. That's a big no-no. Also, you cannot retaliate or threaten retaliation for someone who tells you, no, I don't want to go out on that date with you, or I don't want to do this, or complains about you. You can't retaliate against them. The retaliation section is actually what many lawsuits are about right now. So retaliation is a hot button issue. Obviously, you know, leering, making sexual gestures, or displaying sexually suggestive objects, pictures, cartoons, or posters are also not something you should do. So if you have like a dirty calendar that everyone in your staff can see, you might want to take that off the wall. Making or using derogatory comments, epithets, slurs, or jokes. And this again goes with all those other discrimination things like race and national origin and stuff. You can't make fun of someone based on who they are, who you think they are, and certainly not sexually. So, and again, there's just more of the sexual comments, including graphic comments. So, you know, you don't want to comment on a woman's physique, or if a gentleman has pants on that might be too tight, you don't want to comment on any of that stuff. Stay away. And certainly, you know, don't make obscene gestures or anything like that. You know, I think we're all professionals. That probably doesn't happen too often, but you never know. And physical touching, obviously, or assault. I mean, that's pretty straightforward. Hopefully, none of you are going around actually grabbing people's rear ends or things like that. So, you know, all this information's great, but what does that mean to you guys? So you are agents and brokers, and there are specific issues that you have to deal with under these laws. Property management is a huge one. So if some of you are, you know, building managers or a property management company, you're responsible for how your tenants are treated, even though they're not your employees. You are responsible for providing them an environment that's free of harassment for their living conditions and discrimination. And also, you can't refuse to rent to someone because they're over 40 or because they're this race or that race. So I don't know if any of you guys have had to deal with any of these issues, maybe with your building managers or things like that, but hopefully not. But you are responsible for that. And also with your own staff, some of you probably have assistants and maybe even office managers that work for you. You are liable by how they are treated by your other business relationships. So your escrow officers that you deal with and things like that, you are responsible to make sure they're not harassing or discriminating against your own staff. Does anyone have any questions on that?
how can we handle when the landlord requests the raise?
What?
I think the question was, how do you handle when a landlord requests a rent increase for a tenant?
No, certain raise to rent.
Oh, certain raise? You have to tell the landlord no. You have to educate them and say, we don't discriminate here. You know, you have to open up the application to everyone. You know, it might be time for a new landlord.
You have a business decision.
Yeah. And I think it's better to get rid of someone who's discriminating against people than to get a lawsuit, because we'll go over the penalties associated with lawsuits in a second too, which can be pretty ugly, especially here in California. Anyone else have any questions about this? All right. So, there we go. When is harassment actionable, or when can someone bring a claim against you? Well, there are two forms under harassment, which is the first one, the hostile work environment. I'm sure everyone's heard that term thrown around. A lot of people think, oh, you know, my manager's being really mean to me. That's not a hostile work environment. Hostile work environment is particular to these protected classes. So if you're yelling at your staff and telling them they're idiots, that is actually not illegal behavior, although I would never recommend you do that. But if you particularly say, oh, you're a stupid woman, or something like that, that's when it becomes actionable. So basically, also it has to be something that happens more than once. If someone, you know, blows up and has a fit one time, generally that's not something that you can be prosecuted on. It has to be something that's pervasive or severe. So severe can be a one-time incident, and that's usually tied to, you know, a physical violence or something like that, or someone just says something so horrible that someone is scared for their safety or things like that. But you generally can't be sued. Well, you can always be sued, but you generally won't be held accountable if it's a one-time event or if it's really not that big of a deal. One thing I talked about in a previous presentation I made is how does someone decide if there is actually harassment or not? Well, there's this thing called the reasonable person standard, and basically that means would a reasonable person feel the behavior was harassment themselves? So that falls under the trivial thing. If your everyday person is going to be like, really get over it, it's probably not going to be harassment. But if your everyday person is like, wow, that's really offensive, then that's probably going to be considered harassment. Okay? And harassment is also always, the reasonable person standard applies to the harassed person. So your defense can't be, well, you know, I didn't think it would be that big of a deal. I didn't think a reasonable person would think it would be a big deal. It's always from the harasser's or the victim's perspective, always. And then just to continue, the second type under the harassment, that's particular to sexual harassment, is quid pro quo, which is this for that. So that's basically when someone says, you do this sexual favor for me and I will give you this promotion or this extra vacation or I'll increase your benefits, things like that. Obviously that's the one people back in the old days were more familiar with before the hostile work environment became the big hot button issue. This was the first forms of sexual harassment that were prosecuted. So, you know, don't do that. And here we come to the penalties. So California has very generous juries who like to stick it to employers whenever they get the opportunity to. So, you know, it makes sense that if you're harassed legitimately and you lose your job, you're going to be out maybe some salary. You might, you know, you should probably have to pay your attorney's fees should this all be legitimate. But California awards punitive damages on top of, you know, common sense damages. So that's where you get into these lawsuits where it's millions of dollars. If you are someone with a lot of assets, you want to be very careful because employees can go after you personally. They don't have to go after your company. They can go after you personally if you're the actual perpetrator. So, you know, definitely the lawsuits, you hear it in the news all the time, millions of dollars. It's much better to prevent it than to become the victim of it. And let's say you are an employer and you have a landlord that's harassing or discriminating against your staff or against your tenants, thank you, you will be sued for the millions of dollars, not the landlord. Because you are the employer and you have an obligation to know what's happening in your business and in your apartments and things like that. It's your responsibility to know what's going on. And that's what the law says. So, you know, turning a blind eye and acting like you're ignorant is not going to be good enough in court. And in fact, those are going to get the worst punitive damages because they really want to make a point to say, you should have known what's going on. Why don't you know what's going on? Okay? Any questions about that? And basically, you know, what can you do to prevent this kind of stuff? Well, for your staff and your business partners that you deal with every day, know them. You know, if you have a escrow agent or someone who makes sexual jokes every time they come in, he thinks it's really funny to tell dirty jokes, limit the contact he has with your staff. You know, like if you have an employee who is constantly complaining, I don't like dealing with this person or that person, or this person makes me feel really uncomfortable. You know, take that as a warning sign and limit the contact that person has, that your staff member has to deal with that employee from another organization. And if something bad happens and you're aware of it and you see it, you have the right to go to the other organization and say, look, this person is making my staff uncomfortable, they're harassing my staff, whatever the issue is, you can speak up because you do have an obligation to keep your employees and staff in a safe working environment. And also another big warning sign is noticeable changes in behavior. If you have an employee who's always been on time and never been late, and all of a sudden every day they find an excuse to call out sick or they're coming in late every day, that can be a sign of a personal problem, but it can also be a sign that there's something going on at work and they don't want to be there anymore. So, you know, definitely pay attention to those red flags. Don't turn a blind eye, address them. Again, dealing with it up front, handling the situation is usually better than waiting till a lawsuit pops up. And with that, that's basically it. Does anyone have any questions for me?